Rita Khoriaty. I'm a lawyer at Sumrani Lawyers and Legal Counsels, and I'm also a lecturer at the Faculty of Law of Université Saint-Joseph. I have been working for several years with startups, and based on my experience, I do believe that startups and founders do need to have some legal knowledge about the VC transactions in order to be able to negotiate the best terms they can get in a term sheet. I will start with the term sheet. I guess you all know what a term sheet is. It's a negotiation document that is drafted in the form of bullets. It summarizes the main terms that you agree upon with your investor. In the term sheet, when you sign it, you're not bound to sign the deal and to close it. That means that whenever you sign the term sheet, the only thing that you are undertaking is to negotiate the transaction in good faith. So either you are able to reach an agreement with your investor, and in this case, you close the deal, you sign the final documents, the shareholders agreement, the share subscription agreement, etc. Or you reach a point where you notice that you are unable to reach an agreement with your investor, and in this case, you just break the negotiation. You cut them, and there is no liability on either part. So this is why we say that the term sheet itself is a non-binding document. You have surely heard that. It's a non-binding document. However, be aware, in the term sheet, there could be some binding provisions, such as the confidentiality clause, for example, whereby you agree with your investor that you will not disclose any information, any secret information or confidential information regarding the deal or the transaction. There is also the exclusivity clause, for example, whereby you agree that you will be negotiating exclusively with this investor for a certain period of time, let's say 2 months or 3 months, as from the date on which you signed the term sheet. So those clauses are binding provisions, but the term sheet itself, as a negotiation document, is not a binding document. And whenever you sign it, you can still reach a point and say, I do not want to proceed, and I will cut my negotiations with my investor. I'll give you here some highlights about the most common types of investment in the context of a venture capital deal. First of all, the loan. You can get a loan from an investor. He will be lending you money. He will become a creditor. You will become a debtor, and the amount of money that he will be lending you is considered as a debt. So basically, when he lends you money, you are subscribing to a debt, and therefore you will be paying interest, and you will have to reimburse your loan at a certain maturity date. The second type of investment is an investment in equity, and in this case, your investor will become a shareholder. He's not a creditor, he will become a shareholder in your company, and therefore he will bear the risk of your business as you do. And the amount of money that he will be investing in your company is called a contribution. It's not a debt, and therefore it does not carry interest, and you are not obliged to reimburse it at a certain maturity date. Now there is a third type of investment, which is the convertible debt, which is a kind of hybrid investment between the equity and the loan. In a convertible debt, your investor will start by granting you a loan, and you will give him the flexibility at the maturity date to decide whether he wants to cash back the money in cash to get reimbursed, or to convert the loan into shares, and in this case he will become a shareholder in your company. The most common type of investment in the context of venture capital deals is the second one. So almost all transactions are made on the basis of an investment in equity. What you need to know about venture capital deals is mainly how to read a cap table. A capitalization table is a table that summarizes the names of the parties, the names of the shareholders, the type of shares that they will be holding the company, whether preferred or common, the number of shares, and the percentage of shares that they will have. What I recommend is that you always ask your VC investor to give you simulations to know what will be your exact shareholding percentage at different incidences during the life of your company. For example, at a liquidation event, or whenever an anti-dilution adjustment is triggered. You should know how much you will get diluted, how much shares you will be owning at every incidence. So always ask for simulations. You should also understand the difference between the preferred shares and the common shares. You usually see that in term sheets. Investors will be holding preferred shares. We call them sometimes priority shares. And the founders will be holding common shares. What's the difference between preferred shares and common shares? Basically, compared with common shares, preferred shares are a class of shares that has higher claims on the dividends of the company and on its assets upon liquidation. So basically, you will be giving your investor the right to receive dividends before you do, and the right to receive the liquidation proceeds of your company whenever it is liquidated, also before you do, so in priority over you. You should also know that preferred shares under Lebanese law do hold voting rights. There are no preferred shares under the Code of Commerce without voting rights, contrary to what you see in some foreign jurisdictions like the BVI or the Cayman Islands, where there are some preferred shares without voting rights. Here, this is not possible. Only the banks are allowed to issue preferred shares without voting rights, but companies are not allowed to do so. Another important thing is to understand the difference between the pre-money valuation and the post-money valuation, and this is very important in the term sheet. The pre-money valuation is the valuation of your company before the investment, whereas the post-money valuation is the valuation of the company after the investment. So basically, the post-money valuation is the pre-money valuation plus the amount invested. So let's say that you get an investment of $1 million at a pre-money valuation of $5 million, then your post-money valuation will be equal to 5 plus 1, equals $6 million. And the post-money valuation is very important because it is on the basis of the post-money valuation that you will be able to determine the percentage of shares that you will be giving up to your investor. Basically, you divide the investment by the post-money valuation times 100 and you get the percentage. So in our example, if your investor is investing $1 million at a pre-money valuation of $5 million, you will be dividing 1 by 6, 6 being 5 plus 1, and multiplying by 100, you will get 16%. So if your investor is investing $1 million at a $5 million pre-money, you will have to get 60% of your company. Now, this is the most important, is to give you some highlights and some headlines about the most important clauses that you have to negotiate in your VC deal. First of all, the dividends distribution. What I recommend is that you do not give any priority to your investor as regards the dividends distribution. Don't give him priority and just try to agree with him that he will receive dividends on an as-converted basis when and if you do receive dividends yourselves. So just try not to give him any priority. If he insists on getting or on having a priority on the dividends distribution, then there is two cases, two possibilities. Either cumulative dividends or non-cumulative dividends. Unfortunately, today I have enough time to just explain everything and give examples. It's a Quickshop and it's quite quick. So I'm gonna just tell you that you should avoid cumulative dividends and try to get non-cumulative dividends because this is the best you can get. Another feature of the preferred shares is the liquidation preference. Now, the liquidation preference occurs or is applicable whenever you have a liquidation event. What is a liquidation event? It is basically the sale of the company or the dissolution of the company at a valuation that is lower than the valuation at which your investor invested initially in your company. So let's say in our example that you get to sell your company at $4 million. $4 million is less than the $5 million pre-money valuation. And it's all about knowing how and in which order of priority those $4 million will be distributed among the shareholders. In almost all the deals, your investor will ask you for a liquidation preference. But here there are three cases, three possible scenarios. There are the non-participating liquidation preference, the fully participating liquidation preference, and the partially participating liquidation preference. The best you can get is the non-participating liquidation preference. Just try to push back hard on fully participating liquidation preference. And there is also something that the investors try to get in the context of negotiating the liquidation preference is getting a certain multiple of investment. They try to get like 2 times or 3 times their investment before you start receiving anything. So also here, try to push back hard on that and try to get 1 time the liquidation preference, not more. Another important point is the anti-dilution protection. You always see it in shareholders' agreements and in the term sheets. Anti-dilution protection applies usually whenever the company issues shares at the price per share which is lower than the price per share paid initially by the investor. So whenever this happens, your investor is getting diluted, and he will want to get indemnified, and he will want to apply a certain adjustment mechanism that we call an anti-dilution protection. There is two types of anti-dilution protections, 2 calculation modes: the full ratchet anti-dilution protection and the weighted average anti-dilution protection. Just try to get rid of the full ratchet, never give up on this, and try to negotiate a narrow-based weighted average anti-dilution clause. As to reps and warranties, you always see in shareholders' agreements representations and warranties, and also in indemnification clause. So what are they? The reps and warranties are certain guarantees that you are giving, you and your company are giving to your investor. So basically, when your investor invests in your company, he just wants to make sure that there are no hidden liabilities, that the situation of the company is okay, that there are no financial exposure, that the company has paid all social security contributions, no litigation, etc. So the founders and the company will be making certain guarantees. And if at a certain point in time after the closing it appears that one or more of those representations and warranties is untrue, then your investor will request to get indemnified. And here is where your lawyer should negotiate the most. He should read carefully the reps and warranties, and he should try as much as he can to limit their scopes in order to limit your potential exposure. And the indemnification clause itself should be well crafted. You can, for example, provide that the indemnification is capped, for example, at a certain amount, let's say 1 time the investment. Or provide, for example, that the indemnification cannot be triggered after more than 3 years after closing. So it should always be limited in time. In shareholders' agreement, we also usually see reserved matters or matters requiring consent. Those matters are matters that cannot be resolved by the company's bodies, means by the company's board of directors or the general assemblies, without the prior written consent of a certain majority of shareholders or of the investor. So what I recommend in this respect is to try to limit the scope of the reserved matters, because if you give a lot, you will end up blocking the day-to-day business of your company. If for each decision you will have to obtain the prior written consent of your investor, then you would end up blocking your day-to-day business. So try as much as you can to limit the scope of the reserved matters. And also a piece of advice, always try to get reserved matters approved by a certain majority of shareholders and not the investor alone. Otherwise, you would end up giving veto rights. So just make sure that reserved matters need the approval of a majority of shareholders, not the investor alone. Another important point is the drag-along clause. You know what drag-along rights are? They are rights given to a majority shareholder whenever he receives an offer to sell 100% of the company, to drag the other shareholders into the sale. That means if a majority shareholder receives an offer to sell the whole company, he will be able to force you as founders also to sell your stake in the company. This is a bit dangerous, and you should always make sure that the drag-along rights cannot be triggered unless with the approval of a high majority of shareholders. Let's say the approval of two-thirds or shareholders representing two-thirds at least of the capital. And also negotiate a minimum sale price. Why? Because if you don't negotiate a minimum sale price, there is a risk that the investor or the majority investors sell the company at a low price, they apply their liquidation preference, they get their money back, and you end up getting nothing. So always negotiate a minimum sale price and a high majority to trigger the drag-along rights. Always drag-along rights clause should be read in conjunction with the liquidation preference clause. Finally, the redemption rights. The redemption rights are the rights granted to your investor to force you to buy back his shares if he is unable to exit. Those are not the norm. They are very rarely implemented, and I recommend that you refuse them. If your investor really insists on having them, then you should be careful and you should put strict conditions. For example, that the redemption rights cannot be exercised unless after 5 years from closing. Or, for example, that they cannot be exercised unless the IRR is equal to a minimum amount. This way you would be reducing the possibility or the risk of triggering the redemption rights. In all cases, always make sure that redemption rights are exercisable only against the company and never against you personally as founders, because you will rarely have enough cash to buy back the investor's stake. So just make sure that the redemption rights are exercisable only against the company itself and never against you personally. So this is basically what I had to tell you on this short, quick shop. I wish you good luck during your fundraising phase. Always seek legal advice. And I will give you my business contacts. In case you have any question or you need any legal advice, you are most welcome to come to my office for a free consultation. Thank you. Welcome.